Доброго дня, шановні колеги. Ми розпочинаємо роботу в українському.
We start our working day at Ukraine Crisis Media Center, and the topic is violence against women and criminal justice. Speakers are Alain Laferte, coordinator of the Project Gender and Security Program, Geneva Centre for the Democratic Control of Armed Forces, and Kateryna Levchenko, president of the NGO Strada, Ukraine, Kateryna Cherepakha, project manager of NGO Strada, Ukraine, and Maryna Lehenka, lawyer, director of legal, social, and humanitarian assistance, Department of Strada, Ukraine NGO. Welcome. Thank you, dear colleagues. First, I would like to give the floor to Alain, who is going to present the main results of our research, and then we will add.
Kateryna. So basically, the main aim of the research we have done together with our colleagues of La Strada was to capture. Was to capture basically the response of the criminal justice system. It means police, prosecutors, and judges to violence against women and domestic violence. And so, in order to do so, we have tried to collect both qualitative and quantitative data through a various scope of research methodology. It includes, first, of course, the collection of existing data and statistics related to domestic violence and violence against women. Then the dissemination of questionnaires among professionals, police officers, prosecutors, judges. It included as well the analysis of more than 925 court decisions related to these cases, direct observation of court hearings related to domestic violence and violence against women, analysis of the calls of victims made to the national hotline on domestic violence, which is run by my colleagues of La Strada, and at least in-depth interviews, either with experts on domestic violence or with professionals working in the field of domestic violence and violence against women and in the criminal justice system. So the results, basically all the data we collected through these various channels converge to the same conclusion, which is basically that currently the criminal justice system in Ukraine do not respond effectively and efficiently to violence against women and domestic violence. And to basically show this ineffectiveness, we have identified three different indicators. The first indicator, it's underreporting. It basically means that most of the domestic violence incidents and violence against women incidents fails to be captured by the criminal justice system. They are not reported to the police. This is the first indicator. The second marker or the second indicator of this ineffectiveness is called attrition. It means that when the cases are reported to the police, most of the cases are discontinued within the criminal justice system and fail to result in a conviction of the alleged perpetrator. So this is the second marker of ineffectiveness. And the third marker of ineffectiveness is the non-deterrent sentencing practices. It means that even when the perpetrators are convicted, they are sentenced to a limited sanction, which do not deter them from repeat such offense, and which do not deter other perpetrators to commit as well such offense. And so the question we had after somehow highlighting this ineffectiveness was why such a situation? And so thanks to our survey, we could identify three different markers, three different causes, of ineffectiveness. The first one is gender bias. it basically means, and gender stereotypes, it basically means that the police officers, the prosecutors, the judges are somehow as well human beings and citizens like the other citizens in the society, and as the other citizens, they have some gender stereotypes, and it has impact on their practice as professional. And so, first of all, they tend to minimize the seriousness of the crime. They tend to minimize the seriousness of domestic violence and violence against women. They tend to blame victims for what happened. And they tend to mistrust as well victims. So in short, we can tell that somehow the criminal justice practitioners are not really willing to address violence against women and domestic violence. This is the first reason why the response of the criminal justice system is ineffective. The second reason is the lack of individual capacities. It means that even when they are willing to intervene, even when they are willing to address the situation, they don't have necessarily the capacity to do so. And so, first of all, we got aware that they do not necessarily understand the dynamics of domestic violence. They do not necessarily understand domestic violence as a phenomenon. Second, they have not necessarily the information on the available services supporting the victims of domestic violence and violence against women. And third, they might lack the technical skills to handle these cases. It means that it's not a spontaneous knowledge. If we want, for instance, to collect evidence and preserve evidence in case of rape or in case of domestic violence, if we want to interview victims without secondary victimization, it's not something which is spontaneous. It's not something we can do it like that. We need some skills, technical skills, and the professionals working in the criminal justice system do not necessarily have these skills. And the third causes of ineffectiveness is the lack of institutional capacities. It means that basically the criminal justice system practitioners work in an environment which does not necessarily facilitate their work to handle these cases properly and in line with the international norms. So what does it mean, the lack of institutional capacities? It means that, first of all, there is a lack of training opportunities, which are offered to the professionals. Second, it means that there is a lack of guidance materials made available to them and which could help them to handle the cases and frame their practice, their individual practice. And at last, it means as well there is a lack of human resources and infrastructure which could make them able to handle the cases properly. And we talk in particular about understaffing and lack of infrastructure. Sorry. So basically, at the very end, we can show you just here. We have prepared, oops. Yeah. So here it is. So if we want to make a summary basically of our findings, this is here how we could picture this. So at the middle, basically we have the ineffectiveness of the criminal justice system, which is marked by three indicators: underreporting, attrition, and non-deterrent sentence practice. We have, as causes of this ineffectiveness, gender bias. So people are not willing to address violence against women and domestic violence. Lack of individual capacities. People are not necessarily capable of doing it. And lack of institutional capacities. So the environment does not necessarily allow them to address it. And so at the very end, it has a huge impact for the people because instead of preventing domestic violence and violence against women, we can say that somehow the criminal justice systems tend to sustain and tend to feed an environment which somehow is a climate of impunity or virtual impunity for domestic violence cases and collective tolerance towards domestic violence and violence against women. And basically it's a climate where the victims feel that it's not really helpful to pursue justice, and it's a climate where perpetrators feel basically there is nothing wrong with what they are doing. And this climate tends to as well sustain and tends to feed the prevalence of the violence against women and domestic violence in Ukraine. And so to illustrate a little bit all these aspects, I can leave the floor to the two Katerynas and Maryna.
Дякую, Алан. Я трохи
Thank you, Alan. I will continue your speech. We have not enough time, so we will not present all the results. I would like to tell about what we know very well. Our society is tolerant to violence, and there are factors which facilitate dissemination of violence, its extension. We understand this, but the survey, the research provided us the data which prove our findings, which prove the results. I would like to say about figures. First, 10% of prosecutors, 11% of judges, and 12% of police officers believe it acceptable to use force to beat partner in some cases. These figures, 11% of respondents, they said that beating is normal in families. This demonstrated in the research in Ukraine conducted in 2008-2015. This demonstrates the growth of social opinions, but having this special legal education, prosecutors and judges, they should be different than the whole population in general. I would like to know that to our questioners, the prosecutors, judges, and police officers, they responded, they provided their answers in a very fair manner. They were rather open, we thought that they could respond to our questioners not as they think, but as they should. However, very sincere answers were provided by them, even as concerned the assessment of their own knowledge and level of competence. The professionals, the experts who facilitated our surveys, they also noted this fact. The other figure is 39% of respondents everywhere, both in police and prosecutors and judges, they believe that domestic violence is a private matter. We didn't invent some new truths. Yeah, this is so in our society, and these figures, they are the evidence. We know now the opinions of professionals who work in the justice system. 77% of prosecutors, 81% of police officers, and 94% of judges consider that reconciliation between partners and families is very important, and it, in fact, is the primary aim in cases of domestic violence, not to punish a perpetrator, not to protect a victim, but just to hide the problem from the society. If the partners have reconciled, the further development, this is their own private matter. This is very dangerous thing, as the same concerns the fact that more than 60% of respondents, they believed the cases which were reported by victims, that they are not fair, that this is not truth, that not true information is provided by victims. This is what we found in our questionnaires when we analyzed the cases, the applications from the women's victims of violence. The women say that they were not believed by policemen. All these data would be made public by us. We will report them to the society, to the general public. So now we have figures to prove those assumptions which we had. The gender bias, stereotypes, this bias, this is a negative impact on criminal justice practices. I would like to provide several examples demonstrating the non-serious treatment of these cases. When monitoring was conducted of court hearings, we monitored 77 trials. The trials lasted between 4 and 22 minutes. This is very formal approach because it is too short time to conduct a trial. And then we also analyzed the graphs. If the hearing were scheduled, there were 9 or 10 trials of violence which should have been tried within 1 hour from 9 a.m. to 10 a.m. This is also because the parties in these cases, they didn't appear, alleged offenders didn't appear in courts. Only 1/6 of the cases were called before a judge. So, in fact, we do not have any means to change this situation. We have no means to influence the situation. 2/3 of victims, those who reported their cases to the police, they are dissatisfied with the responses to their information on the part of police officers. Also, we checked in practices the assumptions which we had that private life and behaviors, past sexual behaviors of victims is often used to mitigate the responsibility of perpetrators while verdicts are issued. We give an example of a case which took place in Makarev district, Kiev region, Article 153, sexual violence against 16-year-old girl. The raper, the rape was not sentenced. He was to be in jail for 4 years, but consequently, but later on, because he was an ATO combatant, he was relieved from responsibility for this rape. And the director of Criminal Justice Department can tell us more about this, but there are very many factors. They result in inefficient response of the criminal justice system, which do not promote victims to report the cases, and also do not deter perpetrators from violence. So victims need our help, I would like to say. Thank you. Talking about the gaps and shortcomings which we found, as Alan have already said today, we researched individual and institutional capacities. Several examples of individual capacity the research found. This is not a secret. We feel the lack of knowledge, awareness of legislative and regulatory framework in the field of domestic violence and violence against women. The large share of respondents noted that they have enough knowledge on these topics, but if we look into other questions where we ask them to provide some explanations from their answers, we understand that they do not have such knowledge. Out of 300 judgments which were issued in 2015 concerning domestic violence cases, Article 172.2 defines where the sanctions against the perpetrators, and this was after this sanction was already cancelled by the legislation, and in many cases the criminal actions they were conducted after this sanction was cancelled. And also the institutions which should provide assistance to victims, we see that the experts of criminal justice systems, they have very few information on how, on the services which can provide assistance to women, to the victims. They do not know where to refer women. 45% of police officers, 72% of prosecutors, and 87% of judges that do not have information about services which could be provided, about the institutions which provide services to women victims. I would like to give the floor to my colleague Maryna.
Please be brief. We have 4 minutes until next briefing. So, in the framework of this research, as it was noted, we analyzed court decisions. Unfortunately, the results of the analysis are not really good. And Kateryna said that there are fines, and from 300 decisions, in 109 cases, people were not brought to responsibility. Even if the case was brought to court, the perpetrator avoided responsibility. And the analysis of the decisions shown that in these cases they do not use gender approach. And if this crime was committed in the family, they do not mention this. They only mention that this is domestic violence, not gender-based violence. So the reason is not stated correctly. And also the decisions of court in criminal cases often the perpetrators in gender-based violence cases avoid responsibility or have their sentence suspended and they are not sent to prison. All these figures, we have them. Unfortunately, the analysis of court decision is also bring unsatisfactory results of the work of courts. So if you have questions, please ask. So next briefing is